Now, in an effort to retain its control over the investigative power, Elections Canada has questioned the independence of the Director of Public Prosecutions. That is an astounding suggestion. This is particularly astounding coming from an agency that has worked with the prosecutor for the last 7 years. Since 2006, the prosecutor's office has been responsible for laying all charges under the existing Canada Elections Act. And I quote Section 511(1), if the Commissioner believes on reasonable grounds that an offence under this Act has been committed, the Commissioner may refer the matter to the Director of Public Prosecutions, who shall decide whether to initiate a prosecution. During the last 7 years, while this section has been in place, I have never heard the CEO question the independence with which the DPP has prosecuted Elections Act offences. In fact, not so long ago, Elections Canada was hailing the DPP as, quote, an independent, end quote, officer. And I quote from Elections Canada's 2012-2013 annual report of the agency, quote, Since the creation of the Public Prosecution Service of Canada in 2006, the Director of Public Prosecutions Act came into force. The DPP acts as an independent prosecution authority with a mandate to prosecute cases under federal law and to provide legal advice to investigative agencies. I repeat, Elections Canada said, quote, the DPP acts as an independent prosecution authority, end quote. The agency has reversed itself on this point only now that its CEO is fighting to retain his personal control over the investigative function. He is doing this by having spokespeople cast doubt on the independence of that office. A further protection of the independence of both the DPP and the Commissioner comes from the existing Section 2 of the Director of Public Prosecutions Act, which explicitly excludes the Justice Minister from any prosecutions related to the Canada Elections Act. Let me be more specific. Under Section 2 of the existing Director of Public Prosecutions Act, there is an explicit carve-out that says the Justice Minister or Attorney General is not to be involved in any prosecutions related to the Canada Elections Act. That has been the case for the last 7 years, and that does not change with the Fair Elections Act. Next, Elections Canada has argued that there is an ancient principle that separates investigator and prosecutor, that they cannot reside in the same office. It is an astounding claim. Only 7 years ago, the investigator and prosecutor were not only in the same office, they were the same person. Prior to 2006, with the Accountability Act, the Commissioner of Canada Elections was responsible for both investigations and prosecutions. Most ironic of all, this happened right inside Elections Canada's own office. It is amazing now that the Elections Canada has said this cohabitation is unacceptable when that same cohabitation occurred in its office 7 years ago. Nor is there any precedent to suggest that investigative powers must reside exclusively with officers of Parliament. Police forces, both national and provincial, are placed within government departments. They carry out politically sensitive investigations all the time. They investigate politicians and lay charges against them. Yet, they reside in the executive branch of government. The RCMP investigates members of government and Parliament when needed, yet the police force does not report to the Ethics Commissioner. The police force does not report to the Auditor General or the Public Sector Integrity Commissioner. It is part of the executive branch of government. And I have never heard any credible expert suggest that the RCMP should be made into an office of Parliament. In fact, I would defy you to find a police force that, in Canada that operates out of the office of an agent of a legislature. To suggest, therefore, that there is some sacrosanct principle requiring the CEO's office or Elections Canada control this function is a novel concept with little supporting precedent. In fact, there is no other office of Parliament that has the power to investigate and pursue charges. For example, if the Auditor General or the Ethics Commissioner find evidence of criminal wrongdoing, They do not take that case to the prosecution. They refer it to the police force. And as I said, the police force is inevitably a member of the is a part of the executive branch of government. The current investigative powers of Elections Canada are the exception and not the rule. Finally, and most amazingly, Elections Canada has argued it will no longer be able to communicate with the Commissioner if he is not in the same office. Surely they have email, phones, fax machines. If they need to meet in person, they can walk a few blocks down the street. With these arguments, one is left with the perception that the CEO is grasping to find some justification to remain in charge of the investigator. That control should not continue. It is not appropriate. Under the existing law, there are 34 offences that deal with the conduct of Elections Canada officials. How can the Commissioner independently investigate the agency's employees when he's one of them? How can the Commissioner credibly investigate an agency he works for? Because of the Fair Elections Act, the Commissioner will gain new independence. As a deputy head, he will control his own staffing decisions, and no one else will be able to direct his investigations. The Chief Electoral Officer will continue to have the freedom, just like any other Canadian, to pass along allegations and evidence to the Commissioner, who will decide whether to investigate. There is, furthermore, in the Fair Elections Act, an explicit clause which prohibits the Director of Public Prosecutions from directing investigations by the Commissioner. Now let me turn to the issue of voter identification. Elections Canada has argued that people should not be required to present any physical identification when they vote. This is inconsistent with the practices that Canadians carry out in their everyday lives. You need ID to get a marriage license. You need an ID to pick up packages or letters you receive in the mail by post office. You need ID to open a bank account. Some say that these are not constitutional rights, and therefore they are different. Well, since when does a constitutional right exempt people from ID requirements? Section 6 of the Charter provides mobility rights of citizens. Quote, every citizen of Canada has the right to enter, remain in, and leave Canada. Yet, you need a passport to travel outside of Canada. To get a passport, you need ID. As for entering Canada, here's what Canada Border Services says on its website. Make sure you carry proper identification for yourself and any children traveling with you to assist in confirming your legal right or authorization to enter Canada. We have constitutional rights. Sometimes we have to provide ID to have access to them. And that is consistent with the Supreme Court's own statement on the question in Opitz versus Yasneski, 2012. Quote, however, unlike the rejection of a valid vote, turning away a voter on election day is not fatal to the person's right to vote. If at first that voter could not comply with the procedural requirement with some additional effort, he or she can return to the polling station and obtain a ballot, end quote. Elsewhere in the same ruling, while enfranchisement is one of the cornerstones of the Act, it is not freestanding. Protecting the integrity of the democratic process is also a central purpose of the Act. The same procedures that enable entitled voters to cast their ballot also serves the purpose of preventing those not entitled from casting ballots. These safeguards address the potential for fraud, corruption, and illegal practices, and the public's perception of the integrity of the electoral process. Fair and consistent observance of the statutory safeguards serves to enhance the public's faith and confidence in fair elections and in the government itself, both of which are essential to an effective democracy. The court has said that enfranchisement is not a freestanding right exempting people of any obligation to bring ID. Rather, the requirements to provide some identification to establish your right to vote is a legitimate one under the Constitution, according to the Supreme Court. There are safeguards against voter fraud. In the last election, the safeguards on vouching were violated 50,735 times. These were irregularities. Some have argued these are mere clerical or administrative mistakes of no consequence. That is not the case. The reality is, in Elections Canada's own report, it indicated that they were serious enough that they might lead a court to overturn an election result or invalidate a vote. And here's what the Supreme Court said on the relationship between irregularities and other more serious violations. Quote, in paragraph 42 of the Wisniewski-Opitz decision, the word irregularities appears as part of the following phrase: irregularities, fraud, or corruption, or illegal practices. These are words that speak to serious misconduct. To interpret irregularity as meaning any administrative error would mean reading it without regard to the related words. End quote. In paragraph 43, it says, and I quote, the common thread between the words irregularities, fraud, or corruption, or illegal practices is the seriousness of the conduct and its impact on the integrity of the process. Fraud, corruption, and illegal practices are serious. When they occur, the electoral process will be corroded. In associating the word irregularity with those words, Parliament must have contemplated mistakes and administrative errors that are serious and capable of undermining the integrity of the electoral process. That is how the Supreme Court characterizes the term irregularities. So as we engage in the debate over the meaning of words, I think we should take into consideration what our top court has said in their regard, particularly given that this ruling was on the subject of a contested election, the basis of which was largely irregularities around vouching. Finally, allow me to address the point about transparency. As a minister, I'm required to publicly disclose my financial interests so that the public can judge my actions accordingly. Now, that's not to say that because I have some holdings that I'm automatically to be suspected of some sort of nefarious interest. To the contrary, I disclose these because I'm fully confident that I'm able to do my job regardless of those interests, and I'm prepared to be judged accordingly by the public. It has come to light that some witnesses who have appeared on at the House Committee are paid by Elections Canada. There's nothing wrong with that. The agency's website shows the CEO is paying per diems of upwards of $1,500 per day for advice from some of the witnesses. Now, that should not preclude those witnesses from testifying or having opinions. However, it should require that Elections Canada provide information to all of you so that you can be aware of it and take it into consideration as you make your wise judgments on the bill. It should not be the responsibility of a parliamentary committee to dig through disclosure documents buried somewhere on Elections Canada's website to find this information. The CEO should proactively provide both House and Senate committee members with information on all of the witnesses who have received financial payments from his agency. That is reasonable, that is fair, that is common sense, just like this bill. Thank you very much.